So I read your motion, Ms. Willis. Thank you for that. And did you get a copy of that as well, Mr. Willis?
Yes, I did.
Okay. I read it. So obviously anything you want to add to it, Ms. Willis, that I don't already know, I'll give you the floor and then we'll hear from Mr. Willis.
No, nothing to add.
Thank you. Mr. Willis, your response, please.
I'm not really sure where to start. I know what the biggest issue is.
Okay, you gonna share that with the class or you gonna keep it to yourself?
I'm sorry, I'm just a little nervous.
Why?
I don't know.
It's,
It's like a white coat syndrome. I'm sorry.
I'm not a doctor.
I know. I know the biggest issue is the kids don't like it when I drink at home. For sure.
Okay.
So I mean, I've talked to them about it. And I get it. I understand. And this when something like that is a problem, then it just stops. Like it's not going to be an issue anymore.
Okay. Is that something Ms. Willis can take to the bank, or is that something she's been told before?
About
Hang on, it's rhetorical, but I'll have Mr. Willis answer it first.
Yes, absolutely, 100%. I don't want it to be an issue. I don't want anything bad with my kids. I want them to feel comfortable at my house. They're safe at my house. They're provided for. They're not abused. They're not mistreated. So like, it's turned into an issue, and I absolutely 1000% want it to go away.
Okay, well, Ms. Willis, how do we make that go away?
I don't know if there is a way. I mean, when we were married till now, I don't know him as not drinking. So to just say you're gonna stop, I had the issue in the past. So to just quit is not the easiest thing. But yeah, that is the main thing why the kids don't want to be there. They're nervous with the driving and the drinking and being in the car, and why they did stay here and why they want to live here, and they don't want to stay there. So they've expressed that to me many times, and why we're here today. So,
well, as you might have heard in prior motions, the law does not allow me to just cut off parenting time on a Friday morning. Before you do stuff like that, you have to have what's called an evidentiary hearing. There has to be a lot more to it, but it is obviously well documented. I mean, I will tell you that the move 45 minutes from school, which does impact extracurricular activities and contacts with friends, is the very case that Shade versus Wright, the seminal case in the area of parenting time, involved. It was an extracurricular move away and that type of thing. I think that before I jump into your business, which I'm going to, unfortunately, because I have to figure out a way to do this. I'm not real enthusiastic about, you live in Ottawa County, correct, Ms. Willis?
correct.
And you live, Mr. Willis, in Newaygo County, is that accurate?
Yes.
Yeah, I'm never excited about Kent County residents spending time and resources for two out-of-county people, but the residence is contiguous, so I couldn't transfer it even if I wanted to either to Ottawa or Newaygo. But what I'm going to do is I'm going to find that pursuant to Shade versus Wright, 291 Michigan Appeal 17, a 2010 case, that there has been proper cause or change of circumstance to revisit the issue of parenting time. Obviously, the move by the defendant, and more importantly, the use of alcohol, the requisite best interest factors found at MCL 722.23 are paragraph C, paragraph G is in George, and L. I find that to be relevant too. So what I'm going to do is I'm going to, since I can't do it on a Friday morning, I am going to sign an order of reference to the friend of the court for a complete investigation and recommendation as to what parenting time should be. Are you currently working, Ms. Willis?
Yes.
And Mr. Willis?
Yes.
The fee for that is $300. It will be split between you two. And make sure the friend of the court has all the correct information, because they don't forward mail. I want everybody to participate in this. The last thing I need you to do is this, Ms. Willis. I need you to prepare an order that I will sign that says that the defendant, Mr. Willis, cannot consume alcohol 12 hours prior to or during any parenting time with the children. And you can submit that to me and I will sign it. And if he's serious, and I have no cause to doubt him, because he looked serious to me today, that he's going to, but alcohol is a tough thing. It's a fight every day, believe me. And I hope it turns out the way you want it to, because what the friend of the court may do is, if that gets violated, and that's why I'm starting there, because if that gets violated and there's information that you are doing this in spite of a court order, then there's other means to enforce, such as SoberLink, such as other alcohol testing devices. I'm not going to go there right now. I'm going to take you at your word, Mr. Willis, and just put an order on there for everybody's protection. But you'll be hearing from the friend of the court shortly. Like I said, make sure they have their correct address. Then they'll make a recommendation to me. And once again, the parties will meet with the friend of the court and they can resolve it themselves if they want to. If not, then the friend of the court will do a complete deep dive and talk to whoever you want them to talk to, and they'll review everything you want them to review, and they'll make a recommendation to me. Okay?
Okay.
All right. I wish you both the best. I hope it's a fight, Mr. Willis, and I wish you the best of luck going through that. Okay?
Okay.
Thank you. We're adjourned.